A father learns his son had been kidnapped and molested by the child's karate teacher and ends the teacher's life with a bullet through the head. But can this kind of self-delivered justice be lawful? That's the topic of today's Law of Self-Defense show. And for those of you who stay to the end, I'll share with you how you can join us for our 100% free Law of Self-Defense Hard to Convict webinar coming up in just a few weeks. In February 1984, Louisiana father Gary Pluche discovered that his 11-year-old son Jody had for the past year been molested by the child's karate teacher Jeffrey Doucette. When Doucette kidnapped Jody and transported him to California for illicit purposes, Jody was rescued and returned to his family on March 1st, 1984. Doucette was arrested and on March 16th, 1984, was flown back to Louisiana to stand trial for his abuse and kidnapping of Jody. As Doucette was being walked through the arrival airport by several plainclothes officers, the group passed by a row of payphones. A man at those payphones turned and fired a single bullet through the head of Jeffrey Doucette, killing him instantly. The shooter was immediately arrested without resistance, and that shooter was, of course, Jody's father, Gary Pluche. As he was being arrested, one of the officers asked despairingly, "Why, Gary, why?" I'm pretty sure most of us understand why. In any case, the shooting was captured by news media cameras recording the prisoner arrival. And without further ado, I'll go ahead and play that video for you. If you're watching this content on YouTube, you'll be seeing a heavily blurred version of the video, both in terms of audio and visual elements, to abide by YouTube's policies against glorifying violence or gore. That said, the video we're about to play does involve someone being fatally shot. If watching such a video is something that would make you uncomfortable, it might be best to exercise discretion and stop watching this particular episode of the Law of Self-Defense show. We show such use of force videos at Law of Self-Defense solely for the purpose of legal education and analysis. We neither intend nor seek to glorify violence or gore. With that caution, here's that video of police escorting Jeffrey Doucette through the Baton Rouge Metropolitan Airport on March 16, 1984, when the group encountered Gary Pluche at the payphones wearing a white ball cap, a polo shirt, and wielding a snub-nosed revolver.
Instructor. What happened next was either justifiable or just revenge.
Gary! Why, Gary? Son of a bitch. Police officers.
There's more than one way to inflict serious damage to a person.
The most common reaction I've seen among normal people to the shooting is one of great moral satisfaction. The evidence of Doucette's abuse of Jody Plauché was incontrovertible, particularly in light of the interstate kidnapping of the 11-year-old. Jody's own testimony of the abuse is also completely credible. Incidentally, Jody himself is currently active on X and has given many interviews about these events specifically and life with his father generally. In fact, he's written a book about all this entitled Why, Gary, Why? It's available at Amazon. And I'll include a link to the book in the description to today's show, as well as a link to Jody's X account if you'd like to follow him there. But this is the Law of Self-Defense channel, and we do more than moral satisfaction here. We do legal analysis of use of force events. So as morally satisfying as the shooting is generally found to be, I'd like to take a look at the event from a more technical legal perspective as well. Obviously, shooting people through the head is normally unlawful conduct unless it can be justified on some legal basis, usually either self-defense, defense of others, or defense of property. Obviously, defense of property is irrelevant here, but what about self-defense or defense of others? Could Gary Pluche's shooting of Doucette be credibly argued as being in defense of himself or in defense of his son, Jody? The answer, I'm afraid, is no, because defense of self or others requires that the threat being defended against is an imminent threat, meaning a threat either actually taking place in the moment or immediately about to take place. But the requirement of imminence is like a window. There's a time when a threat is prospective, possible, but not yet imminent. The window of imminence is still closed. Then the threat becomes imminent and defense of force is authorized, assuming the other elements of self-defense are satisfied, and we say that the window of imminence has opened. Eventually, however, the threat stops being imminent and the window of imminence has closed again. If the threat is speculatively in the future or already in the past, then it's not an imminent threat against which force can be used, and claimed as justified defense of self or others. Doucette had certainly committed acts that would have justified his being legally shot by Plauché. Had Plauché shot Doucette to stop him in the act of molesting Jody, or to prevent Doucette from carrying out his kidnapping of the child, either of those would almost certainly have been lawful uses of deadly force in defense of his son. But at the time Plauché shot Doucette, that conduct was in the past. That does not make the conduct any less real or heinous, but it does make it no longer an imminent threat for the use of force law purposes. Of course, in the moment of the shot, Doucette was actually handcuffed and being escorted by multiple police officers, so he wasn't presenting as an imminent deadly force threat to anybody then. Given that there seems no rational legal defense of self or others for Plauché to claim as a justification for shooting Doucette, the shooting of Doucette is certainly unlawful, technically speaking, and therefore a crime. But what crime? Unlawful killings come in a variety of flavors, each carrying different punishments. Some unlawful killings are the result of recklessness, in which the accused did not intend to harm anyone, but was aware that their conduct created an unjustified risk of death, disregarded that known risk, and the death of an innocent resulted. The classic example of this might be a drunk driving homicide. The drunk driver doesn't intend to run anybody over when they drive home drunk from the bar. They just want to get home, preferably without running anybody over. But they know drunk driving creates an unjustified risk of death. They knowingly disregarded that risk when they got behind the wheel. So if they kill someone with their car while driving drunk, that killing would be a reckless or involuntary manslaughter. But clearly, that's not what happened here. Gary Pluche was not merely standing at those payphones, spinning a revolver on his trigger finger out of boredom when it unintentionally discharged into Doucette's head. The shooting of Doucette was clearly intentional, not merely reckless. Another form of unlawful killing is just straight-up murder. This is typically when the accused develops a premeditated intent to unlawfully and without justification end the life of another person, and then does end that life. Importantly, premeditation does not require planning, scheming, organizing, or anything like that. The premeditation required for murder can happen in an instant. It can be a reaction to a mere shoulder bump in a bar, for example, or a challenging look from across the room. Most murders have this modest level of premeditation. Of course, where planning, scheming, or organizing does occur, that certainly establishes premeditation beyond any doubt. And it goes without saying that Gary Pluche engaged in precisely such planning in his shooting of Doucette. Pluche was not at those payphones by accident. He did not bring a revolver with him by accident. He was well aware that Doucette would be escorted by shortly. This is all incontrovertible evidence of premeditation. Indeed, all of this adds up pretty thoroughly to the crime of straight-up murder, a deliberate, intentional, unlawful, unjustified, in the legal sense, killing of another person. And indeed, Gary Pluche was initially charged with second-degree intentional murder. But Pluche would not be found guilty of murder. Instead, he was ultimately found guilty of merely manslaughter. Now, we've already discussed reckless or involuntary manslaughter and understand why that charge would not apply to the facts of this case, but there's a second form of manslaughter called voluntary manslaughter. Unlike involuntary manslaughter, where no harm is intended but results from mere recklessness, in cases of voluntary manslaughter, there is harm intended. The harm caused is voluntary and foreseeably results in death. An example might be a man who comes home early from work and surprises his wife in bed with a lover. In a rage at the infidelity, he whips out a gun and shoots wife and lover dead. Clearly an intentional killing, but arguably not straight-up murder. Voluntary manslaughter is distinguished from murder because whereas a murder is committed with deliberation, premeditation, in cold blood, a voluntary manslaughter is said to have been committed under adequate provocation, in hot blood, under such mentally and emotionally stressful circumstances that the law concedes the killer was unable to form the premeditation, the mens rea, the mental state required of murder. The result is that what would otherwise be a cold-blooded murder is mitigated to a hot-blooded voluntary manslaughter, and that's reflected in a much reduced sentence. Murder is typically life in prison without possibility of early release, whereas voluntary manslaughter might be 10 years with early release perhaps a third of that time. Now, an important condition of mitigating cold-blooded murder to hot-blooded voluntary manslaughter is that the killing was actually committed in hot blood. If there was what the law refers to as a cooling-off period between the adequate provocation event that creates the hot-blooded mental state initially and the killing that occurs ultimately, so that a reasonable person would have regained their mental capacity to premeditate, the killing after the cooling-off period is once again merely cold-blooded murder. In our scenario with the husband shooting the wife and lover, if instead of instantly whipping out a pistol and shooting them upon discovery, he had instead made the discovery, left the premises, stayed in a hotel overnight, purchased the gun the following afternoon, and then returned to the home and shot the wife and lover, that shooting would be more akin to murder than to manslaughter because of the cooling-off period. Well, what about Plauché's shooting of Doucette? Was that committed upon the instant discovery of what Doucette had done to Jody? Clearly not. A full 2 weeks had passed between the March 1st return of Jody to his family and the March 16th shooting of Doucette by Plauché. This is more than enough time to qualify as an adequate cooling-off period that takes the mitigation of murder to voluntary manslaughter off the table. So now we're back to straight-up murder, being the most appropriate criminal charge, technically speaking, for Plauché's killing of Doucette. Nevertheless, prior to going to trial, Plauché received an offer from prosecutors to take a plea of guilty to voluntary manslaughter. He accepted this plea offer. He was sentenced to 7 years in prison with all 7 years suspended, so 0 prison time. He was required to serve 5 years probation, no difficulty for a normally law-abiding man like Gary Pluche, and do 30 hours of community service. Now, we've already learned why a charge of hot-blooded voluntary manslaughter would really not be a reasonable criminal charge for the killing of Doucette, technically speaking, because of the cooling-off period that occurred. So how could voluntary manslaughter still have been on the table? One answer is that the defense gathered together some testimony that provided a certain level of legal smoke and mirrors for any prosecutors who wished to find an excuse to mitigate what was technically clearly murder to mere manslaughter. For example, a psychiatrist testified that Plauché could not tell right from wrong at the moment he shot Doucette. Well, maybe, but technically that would be a legal defense of insanity and an acquittal, if successful, not merely a mitigation of murder to manslaughter. Of course, all normal humans understand precisely what motivated Gary Pluche to shoot Jeffrey Doucette through the head. I expect most of us would be motivated to do precisely the same thing under the same circumstances. Still, the legal framework for unlawful killing isn't really structured to take these emotional factors into consideration, outside of the scope of hot-blooded voluntary manslaughter we've already discussed. So how did Gary Pluche end up with mere voluntary manslaughter instead of murder? Well, because the criminal justice system is not merely some mechanical device into which you feed law and evidence and reason into one end, crank the handle, and get justice out the other end. It's a system run by inherently imperfect human beings with all our normal range of emotions, with all the qualities and deficits, strengths, and weaknesses of any human beings. It's a system that, in a great many ways, is wildly imperfect, yet it's still the best criminal justice system devised. It's imperfect because of the inherent imperfections of the humans running it. Too often, the imperfections I'm describing run counter to what most of us would call justice. Innocent people get convicted all the time. Derek Chauvin is one example. And as I record this show, Daniel Penny is defending himself against manslaughter charges over the New York City subway death of Jordan Neely, and he might well find himself another innocent defendant wrongly convicted. Sometimes, however, the technical imperfections run consistent with what most of us would call justice. People who are technically guilty of a criminal offense are instead not charged or prosecuted or convicted or sentenced as the law might allow, but instead get a break. And that's really what happened to Gary Pluche. The prosecutors in this case and the presiding judge were all, of course, well aware of the context around which Pluche shot and killed Doucette, and they decided that context, those horrific circumstances, warranted a relaxation of the normal legal standards in this case. Now, not an elimination of those standards. Pluche was not simply allowed to walk free. His shooting of Doucette was not deemed a lawful killing, but what should have, technically speaking, clearly have been murder was not only mitigated to manslaughter, but then the manslaughter sentence itself was mitigated to 0 prison time. Now, I want to make clear, I'm not being critical of any of this discretion being used in Plauché's favor. Instead, had the authorities declined to prosecute Plauché at all, I would have had no moral qualms about such a decision on the facts of this case. In fact, I don't really see much reason why the law shouldn't have technical legal allowance for precisely that. I'm just noting that the law, in fact, as written today and as written in 1984, does not have such allowance. Gary Pluche would ultimately pass away 30 years after shooting Jeffrey Doucette in a nursing home at the age of 68. Shortly before his death, he gave an interview in which he stated he had no regrets about shooting Doucette through the head that March 16, 1984. His son Jody was recently interviewed and stated that he regarded his father as the greatest dad of all time. Many people share this sentiment, to the point that even now, in 2024, all these years later, some folks dress themselves for Halloween as Gary Pluche was dressed that day at the payphones. Again, Jody Plauché has a book on these tragic events specifically in his life with his father, generally titled Why Gary Why, and I encourage you to check that out. The Amazon link is in the description to today's show, just a straight up link. There's no affiliate codes or anything like that. And I want to remind all of you, before I wrap up, that you're invited to join us for our 100% free Law of Self-Defense Hard to Convict webinar coming up in just a few weeks. This free webinar teaches you how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. The webinar is live streamed by me. I teach it live, and there's plenty of opportunity for Q&A as well. But we do limit the number of seats to make sure we have adequate opportunity to answer everyone's questions. So I urge you to grab your seat now before they're all gone. And you can do that for free at lawofselfdefense.com/hard-to-convict. I'll close out by reminding all of you again that if you carry a gun for self-defense, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to know the law, so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for lawofselfdefense.com. Stay safe.